Thank you, Guido, and I want to thank the Julius Fund as well for supporting this event. I want to begin with one disclaimer and then make a few substantive comments before the first panel begins. The disclaimer is that I got hit with this terrible cold over the past couple of days, and so I'm probably going to be drifting in and out of consciousness in this event, but I will try to pay attention to everything that's happening. The event is organized, as it says, because, as the title says, because we're experiencing a fair amount of political and legal controversy over exercises of presidential power, and the organizing idea of this is that those problems or issues arise because we're in an era of highly polarized politics. So part of the discussion today will be, I hope, about the interaction between the political environment and the legal constitutional questions that have arisen. I just wanted to begin by sort of preliminary observation about this, and it's provoked by trying to get a handle on the nature of the conversation that occurs outside of this venue, and with the hope that our conversation will be somewhat different. So the external discussion is captured on the one side by the title and subtitle of a recently published book, Lawless, the Obama Administration's Unprecedented Assault on the Constitution and the Rule of Law. And this is one of those things that you can, books that you can open to a random page and find an account of some asserted lawlessness. They range from efforts by the Obama administration to obtain favorable legal opinions on a couple of contentious issues, by consulting outside of the ordinary course of consultation, to the use of waivers under the Affordable Care Act and No Child Left Behind, to what is one of my favorites, taking litigation positions in the Supreme Court that are rejected 9-0 by the court. So that's one set of things. It's probably not irrelevant, although I confess I read the book, but I didn't read the foreword. It's not irrelevant that the foreword is by Senator Ted Cruz. So we have one side of the issue. I couldn't find anything bringing together the other side of these contentions in a single kind of way, but my overall impression of the discussions is that I sort of think of if you compiled the posts on Think Progress about these issues, the overall tone would be, move along, there's nothing to see here. These are just ordinary disputes about how statutes should be interpreted, nothing special about them. There's no rule that requires the administration to take the advice of the Office of Legal Counsel if it doesn't want to. No rule that, that, not no rule, but the waivers are authorized under the relevant statutes. Can't fault a government for taking a litigating position that has prevailed in the lower courts. So all of this is just routine exercises of well-established presidential authority. The hope of this conference, I think, is that we will be able to have somewhat more, as I would put it, nuanced discussions of these issues. That it actually might be the case that some of the things that the administration has done do, at the very least, push the boundaries of previously established notions of presidential authority, and some of the things are either push the boundaries or exceed them, and some of them are just routine actions of a sort that have been taken before. Maybe that'll happen in our discussions, maybe it won't, we'll see. I do want to note that the framing of this issue in terms of an era of polarized politics is, in my view, the most interesting part of it. I will be sitting in for somebody who can't participate today because, and this is not irrelevant for the theme of the conference, she's working with the White House today on the Garland nomination. When I do that, when I participate in the panel, I'll talk about an idea that I published something about 12 years ago called constitutional hardball. I believe we are observing constitutional hardball, and the question is sort of why does it happen? Is there some systematic account of why it might happen? That's the era of polarized politics theme for the day. So with that, I think we can begin our substantive discussions. I do want to reiterate what the Dean said, which is that these discussions are being recorded. Our expectation is that they will in some form be made available to the public, and so you should be aware of that fact. Panel participants, have a waiver form that I'll give you before you leave. Okay, so with that, the first panel is about foreign affairs, and Judge David Barron is going to moderate with Jack Goldsmith and Bruce Ackerman and Heidi Kitross. If you could come up here. We need one more chair. Okay, so pull one around. Yeah, I think that's fine. Okay, so Bruce, I think it's okay. Jack will sit over there. You want to pull that chair? Oh,
okay, welcome. This is truly unplanned. So the plan will be unveiled in the course of the introduction. The panelists that we have are, I'm sure, known to all of you, and so I won't introduce them at length. Safe to say it's ranged from all of them excellent scholars. Jack Goldsmith, who's from Harvard Law School, was the head of the Office of Legal Counsel in a crucial point during the Bush administration. Bruce Ackerman from Yale has written, aside from an entire history of our constitutional tradition, also a significant book about presidential lawyering and the Office of Legal Counsel, both in the Bush administration and the Obama administration. Heidi Kitross has an award-winning book on similar issues with a particular focus on issues concerning transparency. The topic that we start the conference off with is foreign affairs, and the three particular things that the panels have been asked to talk about are Libya, Syria, and the Iran nuclear deal, or as I like to think of them, three things that mercifully I did not have to work on when I was in the Obama administration. And I think what I'd like to do is maybe just start with Jack and go to Bruce and then go to Heidi for some brief reflections wherever you want to start on it, and then we'll have a discussion amongst the three of you that I'll help structure in some way, and then we'll throw it open for everyone to talk. I think we go till 10:15, is that right, Mark?
Yes.
Great. Okay, Jack, you want to start?
Right.
Can everybody hear Jack?
I just speak through. Yeah. Okay. So thank you very much for inviting me today. I'm going to talk about probably a topic with the other. I'm happy to talk about any of these topics during the conversation. I'm going to talk about international agreements, and especially the Iran deal and the Paris deal. There's so much to say about the Obama administration and foreign affairs. I just want to say with regard to the book that Mark showed, there have been books like that. I have them on my shelf for each of the last 5 administrations. There was one after the Reagan administration, after the Bush administration, Reagan, Bush, Clinton, other Bush, and now Obama. There have been books by members of the opposite party talking about how lawless the previous administration was. And they actually had, there are different topics that they had to say for them. The president wanted to get things done that the president deemed important, and the president exercised his authorities as robustly as he could to do that, and the opposition, which lost on many of those issues, saw those exercises of powers as legitimate. So this is, and even constitutional hardball, as you described it, maybe it's a little bit more elevated now, but I think it's been going on for a long time. So I think that the Iran deal, in which the United States led to eliminate many sanctions against Iran in exchange for significant elimination in Iran's nuclear weapons development threat, and the Paris Agreement, which effectuated significant emissions reductions, at least there was an agreement to do so. I think that those will stand as two achievements that are significant for the world on the same level as Obamacare for the president's legacy. And certainly I believe that the president sees them that way, and I think they're of that importance. Now, what's remarkable about two of these most important international agreements in the last, I don't know how long time, is that neither one of them received the approval of Congress. And in fact, both of them were probably opposed by majorities in Congress. So it's a remarkable thing. I just wanted, speaking of gridlock, I just want to give you a few that I think are amazing statistics. If you wonder why the president didn't send this agreement to the Senate, the historical success rate for presidents who send treaties to the Senate, to transmit treaties to the Senate and ask the Senate to consent to them, is 87%. George W. Bush had an 88% success rate. President Obama's success rate is 25%. The Senate has, and he submitted, and I'm not going to assess blame here, he submitted, because it's a very complicated situation, but he submitted many fewer treaties than any president in modern history as well. The Senate in the 112th Congress, 2011 through 12, consented to 2 treaties. That was an all-time low in American history for one Congress. The 13th Senate consented to 3 treaties, which was near the all-time low, and the current Congress has yet to consent to a treaty. So that was not going to be a successful route for the president, nor was it going to be a successful for the for either the Paris deal or the nuclear deal. Nor the president also almost certainly legally could have gone to Congress through bicameralism and resentment, received the approval, and he didn't try that because ex post congressional executive agreements, as they're called, where Congress, after the president negotiates the deal, approves the deal, are even more rare than treaties, and they've been even more rare in this administration. So what did the president do? He stitched together, I think brilliantly, his administration stitched together a variety of authorities. Basically what he did was he negotiated what's called a political commitment on the international stage, and this basically is, not to put too fine a point on it, it's the functional equivalent of a handshake. The president says on the international stage, with regard to the core agreements at issue in both deals, we pledge to do certain things, but we don't make a pledge under international law. Why did he insist on doing it this way? Because if he makes a mere political commitment, he doesn't have to, under our constitutional practices, bring it to the Congress or the Senate. So on the international stage, he convinces his treaty partners to exercise, to agree to this non-binding political commitment. And then separately, the president draws on independent domestic authorities in the Iran deal, the waiver authorities that Congress had given him with regard to the sanctions imposed, and with regard to the emissions reductions, the Clean Air Act, which the president, exercising purely domestic powers, issued regulations under that would have mirrored the requirements under the international agreement. And basically, by stitching together relatively uncontroversial domestic authorities and making a political commitment that Congress had delegated to him previously, largely for other purposes, he was able to tie it to this political commitment on the international stage, which enabled him to avoid Congress. And through that means and some other extremely clever lawyering and politicking, he was able to pull off both deals. These are, I think, these authorities and this move is not completely novel, but at this scale and with this cleverness, it is novel. It's something new. I I expect that presidents wanting to do international agreements and realizing that domestic law provides really extraordinary authorities to achieve change through the administrative state will be combining these two tactics in the future. There's a lot to say about them. I'll just say a few more words and we can talk about the normative issues because I know you only want to speak for 5 minutes. This is a piece of the administration having other initiatives to basically, and I don't mean this in an tendentious way, cut out Congress, because whether it's Congress's fault or the president's fault or the Constitution's fault, that's a larger discussion. Through executive orders, he's enhanced the process of political commitment making through the regulatory state. He's come up with very aggressive interpretations of cases like Curtis Wright and James and Moore to require practically no authorization from Congress to make binding international agreements in other contexts. So basically we're in a situation now, and I'll stop here, where when you combine all of the political commitments, including the two hugely important ones that I just mentioned, and when you take into account the fact that Congress has basically stopped approving deals after the fact, we basically had maybe 15 in the entire Obama administration, or 20 depending on, I haven't been able to get a comprehensive count. Basically, international lawmaking now, or international agreement making now, is a one-person show. It's the president. And Congress has largely capitulated, and the president has just moved forward.
So I'm more interested in the future than in the past. And the first, I have 3 points, at this point at least. The first is Duverger's law. Fundamental principle of Maurice Duverger is a great political scientist. In a two-party system, let's imagine there are 101 voters. And we have, and there are from the left to the right. One is the left, 101 is the right. And there's one, and there's a two-party system, and the one election. Median voter rule. The two parties who are trying to win the election are going to choose candidates and compete for voter 51. That was more or less the system in the United States until 1968. After 68, we have 2 elections. Right? Once again, very simple. Let's forget all about all the complexities. Median voter rule. There's a left and a right. Right? A first election, median voter rule means that number 25 competes against number 75. Then, if during the first election there is the ideologically committed show up with much greater frequency than the befuddled passive middle, Duverger's law would suggest, because what we're looking at is the median voter of the people who are going to participate, is 15 against 85. So that suggests that the Bernie Sanders, Ted Cruz kind of thing is absolutely typical. Absolutely typical. That it is. I can tell you stories. I mean, I've gone through this a good deal. Why it hasn't happened since McGovern, who, after all, is responsible for the rules that have revolutionized the party system in 1972, and then get swiped. We get then we have a number of other races. Usually, we can't run statistics. This is not big data. There have been a very small number of elections, but this is a central tendency of extremism for the presidency. Of course, sometimes. So that's point number one. That our existing system, the combination of the founding plus the progressive area infatuation with primaries, which is now part of the deeply entrenched to say, let's abolish the primary system. That's just like, that's really a fundamental part of our Constitution. Okay, so so we have a potentially extremist presidency, and we might see it today, this time. I'm not good at prediction, but we will see it. It's only a matter of time. 2, we have the a politicization of executive constitutionalism. Let's begin with 1960. At that time, there was the Office of Legal Counsel. There were 15 to 18 people in it. They were all, except 2, except 1, really, senior civil servants, lawyers in the senior civil servants who stayed all the time. That was their career, with 1 political appointee. The first, Sam Rosenman was the first counsel to the president. He was a buddy. Why did Roosevelt call Sam Rosenman counsel to the president? Because he was counsel to the governor when Roosevelt was a governor. He finally seduces Sam to go up to Washington during the Second World War. And Sam is named counsel to the president until John Dean. They were all honorable senior statesmen who were advisors. John Dean is the first person who is counsel to the president. I can tell you about the politics of that, but we'll refrain. He's the first young person. He has 4 people on his staff, 5 people for the first time, lawyers in the White House. And they were doing things like making sure the Filipino waiters in the mess could get their immigration status clarified, things of that kind. Then he gets sucked in. The first real dignified head of the Office of White House Counsel is Lloyd Cutler in 1978. So what we have now is, but now switch to the present. We have a totally politicized White House counsel's office. Every president just wipes everybody clean, puts his own people in there. Totally politicized. And the Office of Legal Counsel is really politicized. Not as politicized as the White House counsel's office, but that's not saying very much. Then we have in Libya this destruction of the custom of the OLC's relative dominance, although, I have tape recordings, and this is of Walter Dellinger and Elena Kagan talking to one another. I'll let you decide who is bossing whom around more. But this, Libya is a very important point, and so, of course, right now is ISIS, the war against ISIS. I don't believe, from everything I've heard, and of course I don't know, that there's even an opinion written by either the White House counsel's office or the Office of Legal Counsel that the justifications, such as they were, have been generated by some kind of interagency committee without any serious and senior law person taking personal responsibility. So this is, so these 2 points, the Duverger point, meaning that we have a structure that we did not have. Abe Lincoln is a centrist compared to Seward because they want to win the election. We now have a mechanism for extremist presidents. And we have this deeply politicized process. Deeply politicized process. This is why and this has grown without fundamental constitutional reflection. And that is what I'm calling for. The particular proposal I made in Decline and Fall of the American Republic, while I was blowing this is the ideal time, was to have a supreme executive tribunal of 9 justices, Article 2 judges, on Article 3 with 9-year terms, rolling over every 3 years. That permits the president to shape the legal structure for the next president. But I won't give you the details, but we need some recognition that, in my words and Neil Katyal's, we need an internal balance of separation of powers in the executive branch, which is serious and structured, to respond to the evident pathologies of the period. To say that a clever lawyering, I take it clever lawyering is, which justifies the ends with the means. You know, everybody everybody in Barron, that's a great thing. You know, everyone doesn't believe that bombing ISIS is a great thing. We cannot justify this deep assault on the rule of law within the executive branch by pointing to some good ends and some bad ends, when President Obama is, notice, you know, he's a constitutional lawyer. He's genuinely a thoughtful and serious person. And we have no guarantee, in the words of Madison, that enlightened statesmen will always be at the helm. And we have, says Duverger, a powerful reason for thinking that he won't be.
So you're feeling good?
I grabbed a lavalier mic, so I should be okay. Well, first of all, thank you to Mark for muddling through illness, and to Dean Minow and everyone else who was involved in putting this together. I'm really, really happy to be here. And I should note, everyone on this panel, moderator included, and you know, everyone else who'll be speaking today is someone who I've read and learned from and been influenced by. So I'm really so happy to be a part of this great event. So what I'm going to do, much like I think Jack and Bruce did, is I'm going to take pretty seriously what Mark told us, which is that, you know, the three suggested subtopics, just a suggestion, and I'm going to, although I will in my remarks mention Libya and Syria to some degree, I'm going to focus a little bit bigger picture on the question of reconciling war powers and national security activities more broadly with transparency and accountability. Now, why am I focusing my remarks in that way? Partly because this is, when I've written about presidential power, I've focused predominantly on transparency and accountability. So in a sense, I'm being a hammer, you know, finding transparency nails. But also, not very surprisingly, notions of transparency and accountability are sort of the common denominator, I think, really across the ideological spectrum that all sort of fall back to in talking about how to reconcile war powers and national security with the rule of law. So in the constitutional law realm, for example, you know, so-called presidentialists talk a lot about accountability and say that, in fact, you know, it favors presidential power because the president is the most nationally accountable, most nationally visible, only nationally elected person in office. Those who you might call congressionalists or anti-presidentialists talk about the way unilateral presidential control can undermine accountability and transparency. You know, furthermore, in some of the recent works more broadly about war powers, Mariah Zeisberg's book War Powers, Stephen Griffin's Long Wars and the Constitution, we see a focus not so much on the formal Article 1, Article 2 requirements, but rather on whether some degree of accountability is achieved. At the same time, as this is kind of an intuitive common denominator point, not surprisingly, the devil is in the details, right? You know, what do we mean by transparency to the extent that there is some sort of constitutional accountability principle that can be derived from constitutional structure? What is it? What are the details, right? How much transparency to whom? When, et cetera. So in my initial remarks, I just want to sort of raise a few issues, kind of a few examples of accountability tools or means for accountability that either have been used or come up in proposals in the context of national security and war powers, and talk a little bit about those. So first, reporting requirements, right? This is sort of the go-to idea or a go-to provision that comes up sort of across the political spectrum in a lot of the proposals from the president's proposal on down for an ISIS AUMF. Everybody kind of joined on the notion that there has to be some sort of reporting requirement. So a few words about those, how they work, how they don't work. Let's take the Libya example, right? So here's one respect in which the 48 hours consultation / reporting requirement of the War Powers Resolution did do some good in that context. We did see the White House within 48 hours of beginning strikes on Libya indeed engaging in a report, right? Now, one can certainly quibble, and I have a lot of quibbles, and many others have mined this territory, with the substance of the report. But nonetheless, I think the 48 hours, within 48 hours report did do some good at minimum in the respect that it became sort of a focal point around which discussion could be had, right? Much of it in the form of criticism, right, about the sort of emptiness of the report, et cetera. But it did provide some focal point for debate, for discussion, some demand for more information. Of course, as I just indicated, that reporting was far from a panacea, right, for one thing. And it was far from a panacea in ways that I think speak to the shortcomings of reporting requirements generally. For one thing, the report was basically presented as a fait accompli, right? The consultation language in the War Powers Resolution was certainly not taken seriously, as opposed to the report. The president, in his 48 hours notice, even used the old refrain that we often see in these types of notices, quote, "I appreciate the support of the Congress," unquote, right? We see this all the time, right? I know Hillary Clinton in a briefing, I can't quite remember which one, but I recall she had an exchange with a senator in which she said, well, actually we don't need your approval, but we certainly welcome your support, right? This is a very common refrain, sort of speaks to a common problem in reporting, which is things being presented as a fait accompli. Now, why is that? Well, part of it is structural in the presidency, right? The president has a first mover advantage, that we're familiar with all the reasons, right? That the president has at his disposal tremendous resources, general Pentagon budget, even without specific allocations, et cetera. So there's the practical aspect, but politics are a very important part of why, as a practical matter, the president so often can get away with presenting things as a fait accompli, right? Because Congress, even when you have a partisan divide, is in a really tough political spot when it comes to national security, right? Nobody wants to be perceived as weak on national security. There are minimal political gains to be had from pushing back against presidential bellicosity, even when it takes the form of objections about unilateralism. So that's one example of, sort of the pluses as well as the shortcomings of reporting. In that example, there were also disputes in the initial public reporting about the 48-hour notification and the bombing, about whether and to what extent there was some consultation with congressional leadership before the bombing began. That speaks to another problem in notice requirements, even when they're before the fact notice requirements, right, which is that they're awfully hard to enforce, for one thing. And again, as a political matter, often that can be gotten away with, and the president knows that, and members of Congress know that. But also, oftentimes it's sort of a he said, she said game about, well, what did the notice consist of, and was there notice? This is something we certainly saw a lot between the Bush administration and Democrats in Congress, right? When it came out during the Bush administration that, interpretations of the torture statute and wiretapping laws, right? All of a sudden, the president said, and the White House said, well, we notified Congress, right? Members of Congress who were notified said, oh, please, there was absolutely nothing we could do about it, et cetera. So that's another political problem with notification, practical limitation with notification. And the last thing I'll say, I took up more time than I meant to with this example, but I'll sort of wrap it up and leave other examples for later, is to say, all of this also occurs in the shadow of Article 2 and the shadow of past and present assertions by presidents, including President Obama, to the effect, if pushed, that, hey, strict notification requirements, really run into Article 2 problems, which I think helps form the backdrop against which a lot of this ineffectiveness occurs. Okay, there are lots of other examples, but I'll stop here for the initial remarks.
Can I say something briefly in response to Bruce? Am I allowed?
Yeah, absolutely. That's the idea.
Okay. So I'm sympathetic to your concerns about executive branch lawyering. I've written a lot about this. But I think that you simplify the problem. This is not a new problem. And to give you an example that will take it away from the supposedly current politicization of the office, let's think about the revered and much beloved Robert Jackson.
Of course, I don't revere and much beloved when he took this dramatic act on undermining the Neutrality Act unilaterally.
Among other things.
Well, and of course, he was a great proponent. How did Robert Jackson get his job? He was the great defender of court packing. This reverence, just because we have the CO Seizure opinion and the concurrence and the reverence, does not mean that we should glorify.
But Bruce, can I just, because
yes.
A question that I was going to ask that I think is at the heart of.
Yeah.
I didn't even
Yeah. No, but I got. No, I want to say. Yeah. And it's a controversial statement. Here we go. But
the point is, it was 1940.
That's what I want. But that's why I want to raise this. Jack, let me just say.
Middle of the road, Abraham Lincoln's Attorney General wrote him an entirely unconvincing opinion about his ability to suspend the baby's focus.
Can I just frame it though? Because this is what I think is. It's useful early on to get this issue out and see whether it matters as an analytical matter, which is, does it matter whether this is a continuous story or there's discontinuity? And there's a lot of the debate about executive power pivots on the axis of, has something new happened? To which a familiar response is, nothing new has happened.
Something new has happened.
And I guess the question is, does it matter
Beautiful.
whether something new has happened? If it doesn't matter, well, then let's talk about that. And then alternatively, how much has really changed and on what vectors and in what way does it matter might be fruitful?
So I think a lot of things have changed. And I think it does matter. Just to mention a few things that have changed, the rise of these executive branch legal bureaucracies are responses to the rise of congressional fine-grained regulation of the executive. In many respects, especially in wartime. And when you have significant and reticulate restrictions on the executive.
Jack, in fact,
There's also
we're
another
gonna do.
level.
No. You sit here. I will sit here. Yeah, I'll sit.
David, do you want a level here?
I'm okay.
Okay.
There's a second mic.
Yeah.
So I'll just say that a lot of things have changed in the last 10, 20, 30, 40, 50 years in terms of regulation of the executive and of congressional executive and congressional White House relations. And a lot of the rise of what you're calling, what you describe as this executive branch politicized bureaucracy is a response to the need to maneuver through all of this stuff. I don't think that the problem is fundamentally different than it was in the Jackson's day or in Lincoln's day, or frankly in the 1793 when Washington, on the advice of his cabinet, issued the Neutrality Proclamation, which your head would have exploded in 1793, Bruce, because it was quite clearly unlawful and a bad interpretation of the treaty. So this is not a new phenomenon. I think it's probably a hard phenomenon to avoid. And I will just, because the executive has, in so many respects, has to make interpretations of law before he can enforce it or before he can act. And of course, we shouldn't be naive about lawyers fitting means to ends. It's not like judges don't do that. And I would only say, and this is a difficult to grasp and justify part of the legal justification process. But what the executive branch lawyers are doing, I believe, is not different in kind, even though their independence is different from what courts do. And that we see courts doing all the time. I would also say, just imagine, David and I discussed this once, imagine if the Zivotofsky decision were issued by the Office of Legal Counsel instead of the Supreme Court. You would never see the Office of Legal Counsel, except maybe in the early years of the Bush administration, issuing an opinion like that, which was basically they were worried about interrupting the president's activities in the Middle East, and so they gave him this broad dispensation to go forward. And the last thing I'll say is I believe with great respect that you're very naive if you think that a bunch of Article II judges inside the executive branch are not going to be co-opted. I don't care how independent you want to make them. Look at how the FISA court is operated, Article III court. It is naive to think that judges in a time, and this is what we're talking about, of military or national security crisis. I'm not saying they don't restrain the president. I believe that the lawyers inside the executive branch do much more so than you do, which may not be enough, but I will just say that I just think that your faith in having another group of lawyers with some form of more independence inside the executive branch is largely misplaced, and indeed what they would do is to confer further legitimacy than the Office of Legal Counsel can on these actions. I'm quite confident that would happen.
Well, first, for a framework, because I do thank you. Here, I think that that we have to appreciate that there has been a 20th century transformation of the presidency. Just consider, for example, the State of the Union address, which was discarded as an address to Congress by Thomas Jefferson on the ground that it resembled too much the speech from the throne, which is the way it was. It was considered to be inappropriate for once we have conventions, for candidates to show up at the convention. The first person who showed up and gave a speech to a party convention is Franklin Delano Roosevelt in 1932. We do have, and the profound, and I mean profound, in 1780s. After all, Publius, as the name suggests, they were very aware that Montesquieu and everyone had told them that republics have no future in the modern world. You can't have a large republic. They were tremendously aware that Caesarism was the death of the Roman Republic. At most, throughout the 19th century, it was very rare for a president ever to give a public speech. The Gettysburg Address, absolutely typical. 3 minutes long, whatever. Edward Everett gave the speech, gave the Gettysburg Address. The only exception is Andrew Johnson, 1866, with his going on the circle, right, and trying to rally the American people against the radical Republicans. Now, during so we have these episodic moments. Jackson's presidency, Lincoln, who, and then Andrew Johnson. I was very fascinated by, I'm an avid footnote reader, your treatment of the General of the Armies Act. In whichever one of the Magna articles you have, here is Congress of the United States declaring that no order by the President of the United States is valid unless it is countersigned by General Ulysses S. Grant. this is the core of the impeachment struggle. So what happens in Woodrow Wilson is, of course, one of the rare intellectuals who become president of the United States. His first PhD thesis in political science in the United States. Johns Hopkins congressional government. He thinks it's total chaos, total vetoes, all this stuff. And that we need a national character. He first wants as a Speaker of the House, and then he becomes President of the United States. It's he who reinaugurates the State of the Union address. And it's Franklin Roosevelt who puts it at night and for the first time puts it on the radio. So this transformation of the presidency from he wasn't, there was a whole debate, as you know, in 1789 or 90 in Congress. What should we call the president? The president is a presider, not the president, not the king. And there was a big debate on what should we call him? His Honor, His Excellency, or something like that. Into the obvious leader of the nation. So in 1789, the most dangerous branch was the House of Representatives. This is the foundational transformation over the last 2 centuries. Now, the most dangerous branch is the presidency.
So just to add a couple of things, I think that's absolutely a key question, right? Has anything changed? And I think it's important to frame responses, and I think you can sort of frame Jack and Bruce's point in these terms to frame them in terms of a distinction between individually changes in light of individuals who occupy the office versus institutional changes, right? And I think there's a lot of political focus on the individual, which is why you do tend to see this partisan flipping, right? That Democrats say the Republican presidents are out of control and vice versa. Politically, that's where the focus is. I think realistically, and I think this is reflected particularly in Jack's remarks, the changes have been more gradual. It's been an evolution in the institution, and a lot of that, have been detailed both by Jack and Bruce at length in terms of the legal infrastructure changes. A lot of other changes, certainly in terms of the military, right? The fact that now we have a permanent standing military gives President tremendous first mover advantages. Also, one other change is I think there's been an important, kind of at the elite legal community level, an important cultural shift. Going back at least to the beginning of the Cold War, but particularly around the 70s and 80s in terms of increasing acceptance, I think, of strong theories of Article II power. Which, among others, Stephen Teelis, the political scientist, has done a great job of sort of documenting, what a concerted effort that was. So you have this multitude of institutional changes, but interestingly, everyone in political discourse is focused on the individual who's in the office.
Let me throw it open to questions, but just one other possible way of thinking about continuity versus discontinuity. We certainly could think of it about the presidency in the abstract, as an office grown more powerful. Another possibility is that what changes over time is less that particular dynamic than the set of concerns that occupy the public at any moment. And then they manifest themselves in various legal developments that pertain to those concerns. So to make that less abstract, we had a Cold War. We're in a different phase. Jack's book is notably not titled the Imperial Presidency, it's the Terror Presidency. That's a particular type of national security crisis which manifests itself in a different set of ideas about how you would combat it that might engender certain responses in which the executive or the legislature would have particular institutional capacities which could be different than the way that would play out in the Cold War. You might think that a particular international challenge now, given globalization, would make domestic authorities more relevant in relationship to international concerns than might have been at other times. So it might not be surprising that you would see this kind of stitching together in the way Jack's discussing. So in that sense, it wouldn't be necessarily more power versus less power. It would be different substantive problems the world's confronting that then play out. And just to sort of put a cap on that, you know, for all the talk of the growth of the president and his power, particularly as a wartime leader, the main focus, or at least a central focus of concern during the Constitutional Convention about the commander-in-chief was whether he would be able to personally command the troops.
Right.
Whatever concerns we may have today, that's not a leading concern we have right now, and that's because of the way national security powers are exercised. They're exercised abroad through means in which it's somewhat absurd to think of the president being in command of the troops. At the time, they were worried about quashing domestic rebellions and insurrections, in which the idea of the president being on the horse, leading them to battle, was a very paramount concern. So I just say that one thing that may be going on here has to do with just the world that we're living in, how it manifests itself, as opposed to some larger trend line one way or the other. But let's open up just to comments. Mike.
This is sort of meant to be question/comment for the entire day. So Bruce, I disagree a little bit with your Duverger's law account, partly because of the mechanisms parties have for moving their nominee towards the center of the national public opinion, such as superdelegates, open primaries, etc. But I take your point, right? The broader point to be, right, the thing I think we all struggle with, which is whatever you think the president you like can do for reasons you like, the president you don't like can do for reasons you don't like, right? And so I want to ask how we should be thinking about that kind of question, right? Because it seems to me there are two different sorts of arguments. One is, I take your point to be a sort of precautionary principle, right? Don't let the president accumulate all this power, probably because any president will do stuff you don't like, but you might get a president who does a whole lot of stuff you really don't like, right? And so the idea, therefore, is to minimize the harm from a potentially bad president. Now, of course, there are type 1 errors and type 2 errors, so you also, therefore, thereby minimize the harm of the president that you minimize the good that you like to do. In foreign affairs, we usually think giving the president lots of power means the president can precipitously take us into war. But notice that in the Iran deal, right, it's the opposite. The Cotton Letter is an effort to say, hey, you're not being sufficiently bellicose towards Iran. So sometimes reining in the president means reining in a peacemaker as against bellicosity. But I take the broader point of view. So the question is the way to think about the question with respect to foreign affairs and domestic affairs and all the other questions simply, what do we think, all things considered, is going to lead to the minimization of bad stuff the president does plus the maximization of good stuff? Or is there some other way we ought to be thinking about it, like conceptually, what does Republican government in our tradition require? Because I take that to be a kind of alternative theme running through this. I don't have an answer to that, I just wanted to surface that question.
Yeah, I was just wondering about, you said, well, what can Congress do? I vaguely remember, and I don't remember the details, Congressman Capuano is suing, or was suing the president for going into some kind of war. So I think that that's what Congress can do. And,
That's not going to work.
Let's say a little bit about why.
There are a lot of reasons it won't work. It's never worked, and largely because there are a variety of threshold doctrines called the political question doctrine and prohibitions on congressional standing that don't allow the Congress to sue the president in that context.
he is suing him.
Well, you can bring the lawsuit, but it won't get past the motion to dismiss.
May I respond to 2 points? One, I do want to agree. Here's a fundamental question that both of us are raising here, and that is how much does institutional reorganization matter? Now, I take it that what constitutionalism is about, before we get to republicanism, is that it matters a great deal. The Enlightenment constitutionalism, is precisely the idea, which is not that the way you organize power is fundamental. Now, whether, given our situation right now, and putting to one side whether there's a political will to do it, whether proposals for internal checks and balances of a more structured kind and more would work, fair question. And but constitutionalism says, that's that this is terribly important, and Enlightenment constitutionalism says it isn't only just like the British evolutionary muddling through, that we can, through self-conscious exercises, and they have been attempted in the post-war 1940s period, the Defense Department Act, the CIA, there was a constitutional, if you forgive the expression, moment there. And then in 1973 to 8, we can talk about, whether the Emergency Powers Act was poorly designed, it was, et cetera, and so forth. So I do think that something fundamental. Then I also, as once again, it's not going to surprise you to say that self-conscious popular mobilization plays, of course, a very important role in my understanding. From my point of view, the present period is not a period of national security crisis. The fact that a few people blew up the Twin Towers in it was a tragedy. It was not a crisis. We will be living with these kinds of asymmetric things forever. This is nothing compared to the Cold War, in which, whatever you want to say about it, there were two nuclear powers who were threatening each other and the world with destruction. There were people, in the United States government who were pro-communist in a way that there were not today. And yet we are taking more striking steps than we did in the McCarthy period.
More striking steps to do. Explain that. Than in the McCarthy period.
The kind of emergency spying and surveillance today is worse than was authorized before. Then we have, we can talk once again about the evolution of surveillance in the FBI. But during the late 40s and early 50s, there was a real crisis. Anyway, so I do think that it is important to have self-conscious, mind you, I'm not at all saying that we don't have a problem. We have a serious problem, and I very much am in favor of an Obama-style resolution. 3 years, we should have regular self-conscious reappraisals. That's where we should be moving. No question about it. But the language of it seems to me the analogy between Abe Lincoln during the Civil War or Jackson during the Second World is melodramatic.
So I just want to add, in terms of, well, two things. First, I do very much agree with sort of disproportionate focus on what's very, no question, incredibly serious threat, but out of proportion to the threat presented. I was listening to a Lawfare podcast actually the other day, and I heard Rosa Brooks offer some statistic that you have a better chance of being smothered while sleeping by your own pillow than being killed by a terrorist. That's not by any means to suggest every death is an absolute
That was also
tragic.
true of the Soviet threat.
Right.
Is that okay? Okay, but
Discounted by the probability was probably
no, but
Especially in my case.
but when you factor in the gravity, right? world annihilation. But in any event, nonetheless, it's a very serious threat, and the political salience is such, right, that I think there's no getting around that being a top issue. I want to say on the front of sort of checks, right? There's only so far we can get with constitutional structural checks. I mean, there's no question. I think it's crucial to do everything we can to try to preserve them, which is what much of these debates are about. But I think you also have to have a system that in multiple ways supports and protects sort of checks embedded elsewhere, not just, of course, the crucial internal checks, inspector generals, et cetera, but also civil society checks, right? And that's a combination of sort of political pressure, but also it depends a lot on legal protections, right? Things like FOIA, support for protection for leakers, et cetera. Seth Kramer has this great term, the ecology of transparency, which speaks to how most of the big revelations involving national security abuses didn't come from one single outlet, right? They came from a combination of things. Somebody leaked some information, then the ACLU FOIA'd more, then there was a lawsuit, more came out in that context. So I think ultimately, there's no silver bullet, but you need to have sort of internal, external, and civil society checks throughout.
Mark, did you?
Yeah, I three observations. One is actually a question to Jack. It's something I picked up on your initial presentation as well, which is, Bruce was pretty explicit about it. I want to frame it also explicitly, which is why shouldn't the words clever lawyering actually be pejorative? Okay, so that's the first thing. The second, on your on David's question about new results, one sort of obvious thing is to say, well, you want to distinguish between things that are continuous, and so, no, it's not new, and situations where there are crudely cyclical things. So it's new relative to what happened over the past X years, although it's not new relative to what happened 60 years ago. And here, just my stick on this is sort of a little is the regime idea of sclerotic is sort of one way of saying, yes, it's new, but it's also old, and we have some systematic way of thinking about the ways in which the new and old interact.
So great.
Well, Mark, just taking that, why does that matter? In other words, for the debate that we're having about executive power and its danger or not danger, what is the significance? I don't mean this as a rhetorical question, I mean an honest question. What is the significance of thinking about it as a cyclical phenomenon? Does it make one, in Mike's terms, should that make one more on the precautionary side? Should that make one less nervous about it? Because, look, this happens, we get through it, we move back to some, ultimately there's an equilibrium over time. How do you?
Yeah, well, so this is, I actually don't know. It's awfully difficult in the moment to disentangle one's, type 1, type 2 concerns from the more general difficulties, the more general phenomena. But one thing might be that it brings out the tension between Bruce's descriptive account of Berger's law and that sort of stuff, and his prescriptive, we need to have a popular moment of popular mobilization of sustained constitutional deliberation. So are the conditions of Berger's law such that you can get the moment of sustained deliberation? And just to I think the cyclical account says, well, you may not be able to know when or how it's going to happen, but there's actually some chance that, notwithstanding the description of the current moment, you can get this sort of alteration.
Yeah.
So I'd just like to say two things. One, Did I say clever lawyering in connection with the international agreement? Yeah. I did not mean anything pejorative by that. I could have said imaginative. I could have said insightful, brilliant, creative. I didn't mean anything pejorative by clever.
No, you didn't. I understand.
No, I know, and I'm trying to tell you why. I don't think the president had a very important goal. I don't personally share all of his goals, but he's the president. He's the one that sets our foreign policy agenda. This is not a new goal. This is not a new role. He thought that these were important goals to achieve, and he wanted to achieve them, and his attorneys found a very legally sound way to do that through what I called clever lawyering. I don't see any reason, maybe that's a poor term, to view that as derogatory. Now, there are ways, it's obviously a term that can be used in contexts that are derogatory. I want to back up and reiterate something Heidi said, and to try to address a lot of these concerns about popular constitutionalism and what are we trying to seek in separation of powers. I actually think that so many things in American constitutional structure have changed. The growth of the presidency, the capitulation of Congress by delegating practically every authority to the president. There's so many different things that have happened. It's hard to know, what you should fix when trying to do a normative analysis. But I will say, I want to reiterate what Heidi said. I wrote a whole book about this, and that is that we don't have the kind of simplistic separation of powers, checks and balances that we used to have. But there are so many points of watching and disclosure and constraint on the presidency. And two that I would emphasize that have been very consequential in this modern era are the press, which has done an extraordinary job. We have by far the freest press in the world. We have by far the leakiest intelligence services in the world. And we do. And there's a relationship between the fact that we're the most robust democracy in the world, I believe, or among them, and that we have the freest press by far. Civil society, David Cole has a new book on this, with which I entirely agree, has been extraordinarily consequential through FOIA requests and imaginative lawsuits at exposing the actions of the presidency, pushing back against the presidency. Even Congress has done some things. Congress has fallen down on the job from what our traditional expectations might be, but there have been all sorts of institutions that have grown up to play the, for lack of a better phrase, checking role. And I just want to point out that there's nothing except for maybe, that I can think of, so correct me if I'm wrong, there's nothing except for maybe the two deals I referred to, the Iran deal and the climate change deal, but not even the climate change deal, only the Iran deal. There's nothing I can think of that President Obama is doing in foreign relations that is obviously unlawful given past precedents or that doesn't have the support of the nation democratically. So what exactly are we worried about?
Charles, then Bruce, maybe we'll wrap up with you.
I think some of this,
Charles, if you could speak.
all of this-
Charles, can you speak up?
I think maybe a lot of this discussion, and particularly Bruce's remarks, are operating under the shadow of a menace. Something terrible might go wrong. Some terrible pathology might take over. What exactly are we afraid of? I don't mean to say, that's not said with an exclamation mark, Jeb. It's said with a question mark. What exactly are we afraid of? I think it's worth articulating. Similarly, those who disagree with Bruce, I must say I'm inclined to be among them. I know what I'm afraid of, and I think we ought to, it's not my turn, but I think those of you in the panel who are raising these specters, and that's not a obloquy, I think there is a shadow on everybody's minds, or shadows at the extreme, worth articulating. And are the shadows real?
And then Heidi, you can.
Sure. Oh, sure, thanks. Actually, I have this mic too, so I probably don't need a double mic. That's okay. So, you know, as to the specters, let me just focus, given the nature of the panel, on war powers, for example. So, even if right now most of us would agree, and I'm really just saying that arguendo. I'm not suggesting we all would agree. I'm torn on a lot of these things myself. But even if arguendo, we all agreed, you know, looking at the details, that substantively we're really happy with, you know, what we're doing in Iraq and Syria, with drones, etc. I am concerned at the absence of political knowledge, the absence of this mattering in public discourse, and not coincidentally, the absence of real congressional participation. And I think there are, you know, a panoply of reasons for that, some of which I referred to, you know, political incentives, political disincentives, president's, you know, the resources at his disposal. I also think it is a real problem. You know, this is kind of the flip from the president's perspective, kind of the ugly dark side of the positive for the president of the changes that I mentioned earlier in perceptions of the president's constitutional responsibilities as not just the, you know, members of political and legal elites, but as, you know, the average American increasingly thinks the president is responsible for everything, right? That dramatically increases the president's incentives to try to get a lock on everything. So that's what I'm concerned of if we're just talking about war powers. I'll leave it at that.
I think we're trying to do three things. One is locate our presence in the longue durée of our constitutional tradition. Are we prepared to say, and these are genuine questions, not, that the traditional system of checks and balances is no longer equal to the challenges of our time? One. Two, if so, are we going to aim for the redesign of our constitutional institutions in the same mode of Enlightenment constitutionalism, as opposed to, you know, step-by-step interstitial muddling through, which is the hallmark of the British tradition of constitutional evolution, and try to preserve foundational elements in our constitutional tradition, although we may disagree what those foundational elements are. So that's the second question, independent of what particular threats I see. But I see Donald Trump right in front of me. Here's a man who, you know, will, have his own Office of Legal Counsel, his own White House counsel, and they will use the precedents of the Obama administration, and every administration, we can count them up, to justify his actions. There is a flip side on the particular. I actually agree with Jack on the creativity involved in the last two international agreements. But of course, what happens when the next president of the United States repudiates them on their first day of office? This will have devastating consequences on the credibility of presidential power for a long time in commitment making. Now, we can say to the previous question, in the spirit of Adrian Vermeule and Eric Posner, goodbye Madisonian checks and balances. Let's optimize and, blah, 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 blah. And that's, I think, and then this casual use of Carl Schmitt, and with worse yet, the misinterpretation of Carl Schmitt. Well, that strikes me as a very, they're in this conversation, and I'm saying, no, we should not say goodbye to the fundamental concerns of the Enlightenment constitutionalism of the 18th and 19th and 20th centuries, actually. But we have to really confront. And this is why, I would love for Jack and I to actually think, because, you see, I've never been an insider.
I was only barely.
Well, but you were there. You were there. And you were an insider.
It was enough to get you on Jon Stewart.
I'm more than happy to figure out what, if any, institutional solutions have half a chance. I'm not totally optimistic. The book is the book on this subject that I wrote was called "The Decline and Fall of the American Republic." I'm not a blazing optimist as to the possibilities of institutional redesign, but I do believe that we owe it to our tradition to try.
Can I say one thing quickly? Please. Quickly. Just a few points quickly. Just from the small to the larger, I don't think that it's so easy, and this is part of the clever lawyering, for the President Trump to repudiate those two deals. And if he did repudiate those two deals, and the reason I say that is because the way that they're set up, especially the nuclear Iran deal, it would almost certainly just hurt us and have no consequences. So anyway, the point is they set them up in a way, both skirting Congress, and that makes it hard, and certainly not impossible, and certainly legally available to repudiate. I don't think it would destroy or have terrible consequences for the President's credibility. I think it would make clear to what everyone already understands about what the nature of this type of deal is. I'm of the view that things are not as bad as Bruce thinks they are. Separation of powers are not like they were in 1789. They've never been like they were in 1789. They're constantly evolving along the British model. I think that the checks on the presidency have evolved along with the growth of the presidency. I think it's extremely difficult to know whether we've gone too far or not far enough because of type 1 and type 2 errors and because of normative contestation about what the right allocation of power is. I would say that I've come to the view that the great evil of executive branch power in the modern era is secrecy. And that I think that just about every concern that we all have about abuses or excesses of executive power can be resolved over the medium term, not in every instance, but that there's adequate checking through a variety of mechanisms. If activities can be exposed, I think our constitutional system does a great job of exposing what the president does. I think it can do better. I think that is the dimension along which the constitutional reform should come. I think it's small level, not large scale, enlightened constitutionalism.
Charles, our fourth panel.
Let me just answer my own question.
I don't worry about any dark shadow.
In the 20th century, there were two things approaching catastrophe. One of them was Iraq, with which we are living and living and living and paying and paying and paying. That's one. And the
war authorized by Congress.
Yeah, that's my point. That's one. The other is a near catastrophe, which would have been a catastrophe of world historic dimensions, and that was if the isolationist Congress of the late 30s had succeeded, and if Roosevelt had not succeeded in undermining, and because then we would have had, Hitler would have won had Roosevelt not done all the illegal things he did. And those were the two catastrophes. And I don't know what to make of that, but I think there's a lesson in it.
Charles, I guess we have 24 minutes. Yeah, I'm
45.
Oh.
I thought we had 10 minutes.
Yeah, I thought it was done.
Organizing technique.
Very
It's like the Price is Right.
I think they're pretty good. Let's give them another 20 minutes. Charles' last point just puts me in mind of a debate that came up really in Truman's time and put most pointedly by Dean Acheson, which is having observed the fight in the run-up to World War II and been through that, and then in the midst of the Cold War, really was quite frustrated by what he said was the obsession with the forms of constitutionalism. and that the forms was a carefully chosen word to, in many ways, put Bruce's framing of what's at stake, which you put in different terms, Madison, which is a way of making it not seem like a form. It's to personify it, right, to make it attractive. But I think in some ways Charles's question is pushing on that, because if what our concern is the substance of national security policy, then he appeals to, he's concerned about a national security choice, he observes that was authorized. And then he says, I'm concerned about a different national security choice, and I observe that had it been up to Congress, it would have come out the wrong way again. So just to the type 1, type 2 point, what do you make of that kind of objection to how you're framing it?
Well, let's get our facts straight first. Why did we declare war against Hitler? We first declared war against Japan. For obvious reasons, they attacked us. Hitler declared war against us because, hold it, because he wouldn't. I want to jump on because I think it will help get the debate. Well, this is. I mean, he is an apologist for authoritarianism. No. Why don't we? No. What do you mean? He is just an apologist for authoritarianism. The Führer, Roosevelt, says, we're going to do it, and so we have done it against the Führer. Now, that's not how it happened. I just want to let you know. The way it happened, the Lend-Lease is not a declaration of war.
He's talking about destroyers for bases.
That's right. That's right. That's unlawful. However, it wasn't getting us into a total war. What got us into a total war was we declare war against the Japanese. Hitler, because of the Axis, declares war. I've read this stuff, actually, in Germany when I've been in Germany a couple of years. There was a lot of talk. Don't declare war against the Americans. He does. We then declare war against the United States. Now, the Iraq thing, so it is not one Führer against the other Führer, the good Führer against the bad Führer, as Charles is portraying it. It was rather there was an isolationist, the Neutrality Act was passed for a reason. It was a self-conscious foreign policy of the people of the United States, not to get involved. Our intervention in the First World War was deemed to be a great mistake. Now, it's always easy after the event, et cetera, and so forth, to, and knowing who was the good guy and who was the bad guy, we have to understand that there was an experience of Woodrow Wilson winning the presidency in 1916 on the ground that he kept us out of war. Then pivoting, fighting, coming to Versailles, and using his theories of the presidency, which are revolutionary theories, coming back and getting repudiated. He could have actually gotten the Versailles Treaty through, but he was so pig-headed that he fought the principle of executive power, so it was vital. Then Hitler arises, and response, and I'm just reporting about public opinion in the United States, in response to this Versailles Treaty, which was repudiated by the United States. Notice. So there was a very broad and collective sentiment. It wasn't only William Taft, it wasn't Taft, and it was then, between 1941 and after the war, we then tried to reorganize with the Bretton Woods, with GATT, with basic institutional structures. One of the most important ones was the construction of the Department of Defense to achieve civilian control over the military, et cetera. So I don't believe that your analysis of the Second World War is at all adequate to the occasion.
The question
Yes.
is not, so you reject those two examples. Charles is asking you if you believe that good foreign policy judgments always align up with what is obviously lawful, and bad foreign policy judgments, that's one of the ways of putting what he's saying, line up. Is that what you think?
The question is, what is a necessary and sufficient condition for constitutional legitimacy? And to what extent does the ends justify the means is a legitimate argument in our constitutional tradition. And I think that under emergency conditions, it is. But that we have to define emergency in a way which doesn't permit the endless emergency, which is where we are today.
Let me
Please.
try to pick up on this thread with Charles and David's question to you, Bruce,
Yeah.
I guess, and figure out what your concern is. So this reminds me a little bit, asking Charles' question, what is it we're concerned about? What precedents are being set now that we're concerned about, and why? It feels to me a lot like, I thought this is where David was going, in the Truman administration. Coppinger and Schlesinger and Atchison are all looking at the Neutrality Acts and saying, that was a disaster for the United States, and so we're going to press notions of unilateral executive power that we previously would have thought preposterous, that in this new world we need to press them. And they do, and then there's the Bruce Ackermans of the world, Corwin at the time saying, you don't know what you're doing because one day someone other than someone you respect will be sitting in the Oval Office. Come Nixon, Schlesinger says, mea culpa, right? I'm simplifying greatly, but
So
it was a mistake, right? I was enamored. I was right about World War II, but these are the sort of, we have to suffer the constraints on the presidency because the Nixons of the world might come along. So that's what is the analogy here? What is actually being done here that you fear will cause the Nixon or the President Trump or the future President Nixon to do something troubling? And here's where my disconnect is.
yes.
Where I come from, within the government, clever lawyering would be dismissed out of hand, right? Clever lawyering is pejorative, and it's not valued. You would be dismissed from the table. Just, you came up with a clever argument.
Yes.
I'm going to give Jack's example. The Iran and Paris deals, it wasn't some political lawyer who came up with the idea of non-binding agreements. These are State Department career lawyers who have been doing this in 90% of the agreements the United States has entered into. These are much more serious agreements than most of the ones that's been used in before. But this isn't something that the White House counsel came up with. And the irony, I think, is that this president has your concerns as Schlesingers. And for exactly that reason. So obviously we were concerned when the Bush administration was making claims we can disregard statutory constraints. It's what we wrote about, it's what we were concerned about. I think the current president was concerned about that. That's a big deal, that not even statutory constraints can bind the president. And that's why this president has, rightly or wrongly, in almost all cases, Burwell being the obvious exception, avoided making that sort of move, and actually avoided making very strong, robust claims of unilateral Category 2 authorities to enter into war without congressional approval. Not John Howard Ely view, but not remotely the Bush administration view, which you never need Congress. Instead, what he's done as much as possible is to tether his actions to alleged statutory authorizations. Contestable statutory authorizations, but public understandings, most of the time, in my view, correct statutory. Not always. I agree with you on the War Powers Resolution mistake, but most of the time, very justifiable statutory authorizations, precisely because he doesn't want to set precedents. And the Jeff Goldberg interview was so striking because the president's saying again that the quote is that he found himself recoiling from the idea of an attack on Syria, unsanctioned by international law or by Congress. And he shocks everyone in the Oval Office by saying, I'm not doing it. I don't want to set that precedent. So what is it exactly that he's done? Stretching statutory interpretations? Congress can, at least in theory, Congress can push back on those. And they have. They've constrained by Guantanamo and I agree with Jack. There's an enormous number of constraints, statutory and otherwise. So be a little more concrete. What powers are you exactly worried about?
Before we get to the examples, because I think that you're understandably concerned with establishing that Obama isn't Bush. Wait a second.
You shouldn't address his motives, Mark. You should address his arguments.
Wait a second. What I'm concerned about is that we are in the beginning of a new era. The obvious one on the legal thing is the doctrine of associated forces. But I really didn't know that. Thank you very much on that other one. Here we have, but I'm not going to. We're not going to argue. I'm not going to argue why it seems to me the doctrine of associated forces has gone way out of control at this point. And to characterize this as an arguable interpretation is a mischaracterization. The key issue is this. We have, just as there are these great events of lived experience, the Second World War, the elaboration of an institutional setup, then 1989, and this triumphalism. And now we are in a different era in which the doctrines of the Obama administration authorize endless war. Endless war under the associated forces excuse. This is never going to be a sanction as a result of publicity, because, of course, the Obama administration correctly is going to say, we can't tell you all the dirty facts linking Al-Qaeda to ISIS to Al-Shabaab, et cetera, and so forth. But you'll have to believe us, there really is something there. The thing that is restraining this endless war is the judiciousness of this President of the United States, not the legal doctrines of the Obama administration. Now, I happen to agree with you on other issues. For example, let's take immigration. I think that the chart, we have to do, case by case, nuts and bolts, as to which things are within a plausible interpretation of presidential authority and which things aren't. But so my paradigm case is the endless war, which is legitimated doctrinally by aggressive lawyering that would not pass the serious consideration of judges if they were involved.
Heidi, I'm going to come to you, but I want to make sure Greg gets
Go ahead.
In response to Marty and Jack and Bruce, one of the things
Charles.
Yes. One of the things from 15 years of multiple perspectives I would be concerned about is excessively creative lawyering, and that being a culture in the executive branch of applauding creative lawyering. And to Marty's point about, okay, we don't want to ignore statutes in support of a constitutional override. That is, as you know, strongly supportive of what you all have written about that. But you said, so what are we concerned about? Just stretching statutes? Yes. I am concerned concerned about just stretching statutes beyond what they can plausibly be read to mean. And I think there's an excessive culture of that in Republican and Democratic administrations that leads to, and it's combined with a culture of statutes are infinitely malleable and words don't really have meaning, and we can say anything's ambiguous. And once we say it's ambiguous, well then we're good
That's
to
Chief
go.
Justice Rob.
No, that's enough. And I'm, I don't think this is true all over the place, but I think this culture leads to stretched interpretations, which is a problem, and there's not as much a culture of, Mr. President, you can't do this. And I think we should create more of a culture of, Mr. President, I love the ends are important, but we can't get there. And I saw that in the White House, and I see that, I think, from a more distant perspective now. And I think it's related to both how we think about words and statutes and how we think about the term creative lawyer.
Greg, just to, because I think this might go to Mike's important question about what's the, when we make a recommendation, we should be more like this rather than like that. Well, what's driving that? So one would be kind of a consequentialist idea, which is it's important to do it because if you don't do that, your experience was that's how you get in a lot of mistaken policy judgments. Another would be the reason you do it is more formal or more traditional or some notion of how the republic operates, which is it's important to say no to the president, not because the president can't do it, but because the president will then be able to go to Congress and Congress will approve it. So I have no interest in whether the policy should be X or Y. I'm really interested in the process through which that policy is developed. I don't know if you have a thought about that.
It's not surprising given my current job. I'm more formalist, rule of law oriented on that question. But I also, I do think when you stretch statutes and say everything's ambiguous, you lead to problems in the executive branch. And I think, what does hostilities mean? What does severe pain mean? You get to places that are going to be bad in a policy outcome when you don't read statutes to mean what they say. So I guess I would connect my views, which are not shared necessarily about statutes having some meaning, and the culture in the executive branch, which is let's find a way. And let's find a way is not necessarily a great culture. It's not everywhere, but certainly Jack wrote a whole book about it and experienced it more than anyone.
Heidi.
Just a couple of points which I think are responsive both to Brett's statement and to Marty's question. So, one thing that the Obama administration did that did concern me in terms of an Article 2 assertion, and this wasn't justifying circumvention of a statute, but it was objecting to a statute on Article 2 grounds. I think this was the form of a 2009 policy statement and then again a 2010 policy statement. You might recall that there was proposed legislation to tighten up the Intelligence Committee notification requirements to tighten up the exception where, the cases in which the president could notify just the Gang of Eight rather than the whole intelligence committees. And Obama did make, I think again through a White House policy statement, an Article 2 based objection to that. And then what I thought was a particular stretch was it was then revised, and the recommendation was okay, he can still notify the Gang of Eight in situations where he can notify the Gang of Eight, but when he does that, he has to tell the intelligence committees that he told the Gang of Eight something that he's not telling them. And there was an objection to that too. So that I did find troubling. And just one other comment, and this very much relates to Brett's point. So the question of what Peter Shane has called a statutory stretch argument versus an Article 2 argument. It's interesting. So Peter Shane has written this article recently, I think it's called The Statutory Stretch, where he argues that he thinks it's less damaging when the president and his advisors make statutory stretch arguments rather than Article 2 arguments, which I'm not sold, but I sort of throw it out there as, you know, an interesting argument, although ultimately I worry, for reasons you said, that it's more damaging and in many ways, you know, more tempting and more insidious because it means more acceptable.
Just to be clear, consistent with Marty and David's article, I actually think it's less damaging than the unilateral argument, but I think it's still damaging. It was my point, which is it's not something to be applauded to go statutory stretch, but I do agree. I mean, it's less damaging to the structure of our system than the unilateral argument.
Okay.
Well, we are actually now at the end.
You don't deserve 20 more
I'm sorry,
minutes.
Jack.
I was just going to say one quick thing.
Yeah.
In response to Bruce, so if that's your worst case for the Obama administration, the endless war, I agree with you that it's an unpersuasive. First of all, with regard to Brett, stretching statutes is not new to the recent culture in the executive branch, nor is it limited to the executive branch. Look at the Supreme Court, I would say, frequently. So this is a problem of lawyers, maybe not appellate court judges who are bound. It can be reversed, where you have to follow the law. Also true of lower level executive branch. That's also true, by the way, of lower level executive branch lawyers. But always at the top, I would say, of any institution that's self-judging, there's going to be stretching. So, I don't think the executive branch at the top is any different from the court on that. With regard to endless war, if that's your best example about where legality would really matter, I agree that extending the AUMF to ISIL was an unpersuasive stretch. The president could have done exactly the same thing that he's been doing under Article 2. It would have been completely consistent with past actions of the president. The reason he couldn't go that route, and I'm confident the reason he didn't, is then he would have war powers resolution constraints that he would have had to stop after 60 days. So in the ideal world, and this is what the president should have done, and he wasn't willing to expend the resources on it, and he should have gone to Congress. But if you think that following the separation of powers details would have ended endless war, I just think that's a fantasy. And if anything, the Congress of the United States was pushing Obama from, I don't know what's left and right, they were pushing him to be more warmongering. So I don't understand why that is a great example of why crossing our legal T's and dotting our legal I's would have why is that a good example for you?
It's wonderful, you know. Let me just throw in Clapper lying to Congress. As another wonderful thing that the President of the United States has given us. I just want to close with the sense of oddity here. I was walking by something called Langdale Hall, and I hadn't really yet appreciated that what was going to happen is that Ackerman from Yale comes to Langdale Hall to hear the voice of legal realism.
You're a backward-looking formalist.
I mean, absolutely. And I am appropriately humiliated.
Okay, I think we'll take. Are we taking a break now, Mark? Okay, thank our panelists.
A lot of fun.
Good to see you. That was fun.